Am I audible to people in YouTube? They shall reply yes or no. आप लोगों को तो आवाज आ रही होगी, right? Okay. So in the last class there was some confusion about one question about sedition. So in today's handout you will find the explanation about that in clarity in very last. So the debate was that whether the freedom of speech and expression can be curtailed on the grounds of sedition or not. So few people were saying it cannot be, but as of now, if we talk about till today, sedition is one ground, though it is not written in the constitution, it is not written in the article 19, but your freedom of speech and expression can be curtailed on the grounds of sedition. Now how did it happen? So there are 2-3 cases. Based upon that and based upon the judgments of the Supreme Court, sedition can be used as a tool to restrict the freedom and expression of people in India. However, there is a long debate going on right now in the country. The court has also given this direction to, for the time being, hold prosecution under the sedition, but that is a different matter. The question was asked that can sedition be used to restrict the freedom of speech and expression or not? So the answer you will find at the very last in your handout. There are the 2 cases, Ramesh Thapar, and there is one another case, right? Okay. So far we have done around 75-76 questions in our RTFQ for polity. I think that your RTFQ for history is also going on. Modern history chal rahi hai. Economics I think is already done. Done na? Okay, polity, economics, modern history. Where? In modern history. Okay, economics. That will also be done. Right. So in today's discussion around 50 questions, we shall cover the remaining portions of fundamental right. You will find 1 or 2 questions from the executive also, but executive not per se I have touched. We shall discuss about the executive in the tomorrow's session. So let's complete till fundamental right, DPSP and fundamental duties, right? Mostly the question you will find today is from fundamental rights and also from current issues related to rights, right? Okay. So the first question is again about this 124A IPC, that is sedition. Sedition 124A IPC. So it says it is an assertion region based question. The law defines sedition very broadly, right? Very broadly in the sense there is no concrete definition. There is no concrete definition of word sedition given in section 124A. Now that is very broadly, if you interpret the law, if you sit to interpret the law, broadly means that there is not an exhaustive definition given. If I say like simply that all the criminals should be prosecuted, all the criminals should be prosecuted. But what do you mean by criminal? This is a broad definition of the criminal. Anybody doing crime, right? That is a broad definition. It will include various things. So what is the problem in defining anything very broadly? It leaves ambiguity in the minds of the interpreter. And it also gives certain scope of arbitrary exercise in the hands of police. It's also happened in the terms of freedom of speech and expression. If you remember the case of Shreya Singhal. Have you read the case of Shreya Singhal? So there was one case in which a girl tweeted something, right? So there was a section under section 66A of the Information Technology Act. So that says anybody who is hurting the feelings of someone via the use of internet. Now it was simply written someone who sends the message or use the communication media for hurting anyone's sentiments. Your sentiments may be hurt very sensitively. My sentiments may be more strong. It may not get hurt so sensitively, right? So it was also again a very broad definition, right? So what the problem in the broad definition is that it gives too much scope of arbitrariness in the hands of law enforcing agency. Now this is actual problem which is there in laws like this sedition. It is also one of the problem in the laws like APSPA. Right? APSPA is a 7-section act, but that has created a trouble in our country for more than 60 years. It simply says certain areas shall be declared as a disturbed area. So how do you define the disturbed area? Right? What is the classification? What is the criteria? That is not mentioned in the act. It depends upon the executive to define. And wherever there is such scope of arbitrariness will be there will be chances of abuse of power, right? These are all the issues which will be more once you will be covering for the mains examination. But let's see this question. The law defines sedition in a very broad way. This is true. There is no clear cut, there is no exact definition of sedition given under section 124A of the IPC. Right. Now, what is the reason they are trying to say that sedition is a non-bailable and cognizable offence? Statement is this, second statement is also true, but do you find, ऐसा तो हमारे आईपीसी में बहुत सारे नॉन बिलेबल कॉग्निजेबल ऑफेंस है, but all of them are not broadly defined. Now, if you go and read section 299, 300 of IPC that talks about culpable homicide and murder, that is one of the exhaustively, like very in detail explanation. That is giving you 4 or 5 illustration कि ऐसा होगा तो मर्डर होगा, ऐसा होगा तो नहीं होगा वो मर्डर. That is in detail explanation. Still they are non-bailable cognizable. तो ऐसा जरूरी नहीं है कि जो non-bailable और cognizable होंगे उनको broad में definition कर देंगे. However, both these statements are true. Now, do you understand the meaning of this non-bailable and cognizable? What do you mean by non-bailable? You can police station. And what do you mean by non-cognizable? Right, right. So usually what happens that if anybody is committing any offense, right? So they have to be punished. They have to be punished by the courts, of course. गाड़ी नहीं पलटाते हैं हर बार, कल पलट गई, ठीक है, कल पलट गई एक बेचारे की फिर से, ठीक. तो offense shall be prosecuted. Now, who is the persons who are, which are the agencies which will be behind this whole criminal trial? Firstly, police. Police has got the duty to arrest and take the culprit accused to the courts, right? So there are classes of offences in which police can arrest a person even without any need for arrest warrant. Those category of offences are called non-cognizable. So non-cognizable, police can arrest without warrant. These are though a legal term, but these are so popular in the newspaper, it may be asked also in the question कि non bailable का मतलब ये होता है, cognizable का मतलब ये होता है, then you have to filter out the statement, right? तो ऐसा नहीं कि ये irrelevant हमारे लिए बिल्कुल भी. These are the legal term, purely legal term, but this still these are the relevant for our preliminary examination also. ठीक है? So in non-cognizable offences, police can arrest without the warrant. And a registration of FIR is mandatory in the case of in case of cognizable offense. In case of cognizable offense, police can arrest without warrant. In case of cognizable offense, police can arrest without warrant. And in case of cognizable offense, registration of FIR is mandatory for the police. If you are going to report anything which is cognizable in nature, police cannot deny the registration of FIR. If police denies, you can go to the superintendent of police. Ideally, आप पुलिस थाने में जाते हो जहाँ पे SP नहीं होते हैं, SHO होते हैं, है ना? So if the SHO or upon his direction any police officer refuses to register the FIR, you can file a complaint to the superintendent of police. Even if the superintendent of police, however, he will be in the same department, still he also refuses to register the FIR. In the case of this cognizable offense, you can approach to the court directly and you can file the complaint there. That is called complaint to the magistrate. एक पूरी चैप्टर लिखी हुई है सीआरपीसी में, सेक्शन 190 से लेकर 206 तक, ठीक है? तो आप डायरेक्टली मजिस्ट्रेट के पास जा सकते हैं. देन द मजिस्ट्रेट विल डायरेक्ट द पुलिस कि आप FIR लिखो, क्यों नहीं लिख रहे हो, बिकॉज दिस इज ए कॉग्निजेबल ऑफेंस. तो दो रिपरकशंस होते हैं कॉग्निजेबल ऑफेंस के. पुलिस कैन अरेस्ट विदाउट वारंट एंड registration of FIR is mandatory. When the registration of FIR becomes mandatory, the investigation is also mandatory, because once a FIR is registered, it is the duty of police to investigate the matter and file the final report before the court. इसीलिए पुलिस वाले तो रजिस्टर नहीं करते FIR, क्योंकि उनको इन्वेस्टिगेशन करनी पड़ जाएगी, राइट? ठीक है. Now in the non-bailable offense, in the case of non-bailable offense, Can you please call him? Where? Who is running that? कहाँ से आएगा ये? चल क्यों रहा है? अच्छा ये, ओह वाह, डिस्टर्बेंस, एक्ट ऑफ गॉड। भगवान जी चलो, so this is one sort of classification of offenses into cognizable and non-cognizable. Now there is another classification. What if police person arrest a person? You know, this is the fundamental right of every person, that once arrested they cannot be detained for more than 24 hours. Within 24 hours they have to be produced before the nearest magistrate, right? So once the person is produced before the magistrate can either grant him bail or send him to the police custody or send him to the judicial custody, right? So bail is the temporary release of a person while his proceedings are under process, right? So on the grounds of getting the bail, who can give the bail? When a bail can be sought by any accused? All the offences have been classified again into the two kinds. One is bailable and another is non-bailable. So one is bailable and another one is non-bailable. So in the case of bailable offences, usually these are very petty offences, 2-2.5 साल से कम वाली सजा वाले जो होते हैं, बट ऐसा कोई स्ट्रिक्ट रूल नहीं है दैट 2 years and below. There is a schedule under CRPC, उसमें जो भी offences are mentioned as bailable, they all are bailable, right? But what happens in the case of bailable offence, that if a person is arrested, he may simply go to the police station and someone on his behalf will furnish him bail. Bail is what? A security. It is just of a bond of good behavior, that this person will not fly away from India. Wherever the police will require, he will present himself to the police for the further investigation, right? So police can grant the bail in the case of bailable offences from the police station itself. बंदे को अरेस्ट किया, आने लगे, वहां पर उसने पर्ची भरी, वो घर आ गया, that is bailable offence. But under the non-bailable offences, police cannot grant the bail to person. Who can grant? ऐसा नहीं कि उसको bail नहीं मिलेगी. It is the discretion of the magistrate to grant him bail or to deny him bail. So these are the 4 categories of offences generally. Now there will be, अगर कभी examination में आपका सामना हो जाता है, there will be another 2 category of offences. One is compoundable offence and one other is non-compoundable offence. So in compoundable offence, you can negotiate the terms. कुछ समझौता कर सकते हैं. Out of the court settlements can be done. But in non-compoundable offences like डकैती, rape, murder, all these are heinous crimes, and here no negotiations can be done. So these are called non-compoundable offences, right? Okay. So in this question, first statement is also true, second is also true, but the second statement, that is the reason, is not the apt reason for the first statement, right? So what is going to be our answer here? B, that both A and R are individually correct, but R is not the correct explanation of A, right? Clear? Let's move on to our next question, that is question number 78. All? Generally they are, but it is not a rule. All cognizable offences, you will find certain offences in the Motor Vehicle Act which are cognizable offence. बिना लाइसेंस की गाड़ी चला रहे हैं, दैट इज अ कॉग्निजेबल ऑफेंस, बट उसमें आपको बेल मिल जाएगी. बिना लाइसेंस की गाड़ी आपके पास, यू डू नॉट हैव द परमिट, यू डू नॉट हैव द लाइसेंस टू ड्राइव द व्हीकल, राइट? दैट इज अ कॉग्निजेबल ऑफेंस. दैट इज अमाउंट जस्ट, सी लाइसेंस क्या होता है, दैट ऑथोरिटीज हैव टेस्टेड योर स्किल्स एंड दे हैव गिवन यू द लाइसेंस टू ड्राइव ए व्हीकल. नाउ यू हैव नॉट बीन टेस्टेड फॉर योर स्किल, यू आर रनिंग विथ अ वेपन टू किल. आप रोड पे गाड़ी लेके आ रहे हो जिसको चलाना आपको नहीं आता है ऑथोरिटीज की नजर में, भले आप प्रो हो गए, रोज रेसिंग करने जाते होगे, लेकिन कानून की नजर में यू आर नॉट स्किल्ड इनफ टू ड्राइव द व्हीकल. दिस इज व्हाई दे हैव नॉट फर्निश्ड यू द लाइसेंस. फिर भी आप रोड पे लेके आते हो, दैट इज अ वेरी सीरियस इशू. यू मे अमाउंट टू मर्डर ऑफ समवन. रोड पे चढ़ा देंगे, फिर पता चलेगा गाड़ी कौन चला रही थी, तो साहब का ड्राइवर चला रहा था, साहब नहीं थे उसमें. So there are, yes, please. Hmm. Hmm. पुलिस की जब द टाइम ऑफ द अरेस्ट, इट्स नॉट अबाउट द प्लेस, इट्स द टाइम, 24 घंटे के भीतर असम में जाके किया है. हाँ, अब वो दैट इज वन कंफ्यूजन. So firstly what happens that if the Delhi police is going to Assam and he is catching a thief or a criminal there, right? So 24 hours shall be counted from the time of arrest, right? But it is not practically possible to come from Assam to Delhi within 24 hours and then to take to the nearest magistrate in Delhi, because the jurisdiction of the magistrate lies in Delhi. So what is the possible option? Firstly, the police will present the arrested person to any judicial magistrate there in the Assam. They will get the transit remand prepared and then they will take it. Now while the transit remand is prepared, the journey time is excluded. The journey time is excluded from counting of that 24 hours. ठीक है, तो अगर कहीं दूर पकड़ा है तो जर्नी टाइम के अलावा 24 घंटे. ठीक है, चलो. So this question number 78 says, according to the Supreme Court of India, right to protest is a fundamental right. Now second statement says, according to the United Nations Human Rights Committee, right to protest is also a fundamental human right. Both these statements are true. Both these statements are true. Right to protest is a one fundamental right. It is, but right to picketing, strike नहीं है आपके पास. ठीक है, strike नहीं कर सकते, protest कर सकते हो आप. ठीक. So both these statements are true. Our answer is C. According to Article 94 of 19, subclause 4 of the Indian Constitution, the reasonable restrictions on the freedom of association can be imposed upon the grounds of, there are 3 grounds. You have to decide upon which grounds the freedom of forming associations can be restricted. We have Article 19, subclause A, that gives you 6 kinds of freedom. 2, 3, 4, 5 जो आर्टिकल्स है 19 के अंदर, that imposes certain kinds of restriction upon each of the freedom you have got. For your revision purpose, you need to make a table. ये हमारा freedom of speech and expression, ये है उसके restrictions. This is our freedom of association, ये है उसके restrictions, right? तो यहाँ पे क्या आएगा हमारा? Our freedom of association can be curtailed on 2 grounds: public order morality, sovereignty and integrity of India, right? Sovereignty and integrity of India. तो यहाँ पे we have the option 1 and 2 as correct. अगर आपने ऐसा टेबल नहीं बनाया है, then you can ask any of your prelims master program friends. वहाँ पे उन लोगों को मैंने टेबल बनवा दिया है. Presently the inner line, I think this question we have done, है ना, किस किस स्टेट में होता है. In which of the following judgments did the Supreme Court upheld that the individuals have a right to die with dignity and allowed a passive euthanasia for those who are terminally ill or suffering from incurable situations? Aruna Sonbog, any other opinion? दोबारा से क्वेश्चन पढ़ो. Anyone from online who wants to give the answer for question number 81? Komal is asking, please explain cognizable and non-cognizable. So, in cognizable offences, police can arrest without warrant and it is mandatory for police to register FIR. In non-cognizable, police cannot arrest without warrant. They will first need to secure warrant from the magistrate and then only they can arrest the person. Now, in 81, question number 81, which of the following judgments did the Supreme Court upheld the individuals have a right to die? Aruna Sonbog कब का केस है? 2011, right? When did this euthanasia became legally recognized in India? 4 साल पहले. In Aruna Sonbog case, court overruled. Case is related to euthanasia, but in Aruna Sonbog case, the court overruled that euthanasia is not your right. It was later in the Common Cause versus Union of India 2018 के केस में. Now, court finally agreed that euthanasia is kind of your right. Why? It is inscribed under Article 21, right to life. You do not have right to die. आपके पास right to life है. You do not have right to die. Then why we are allowing euthanasia? We have right to live, but right to live with dignity. आप एक ऐसे स्टेट में हो जहां पे आप you are not able to do any physical functions. You are living on the mercy of others. That is no manner a dignity. Manual scavenging is banned in India. Why? It is against human dignity. So it is everyone's life in India. We all have the right to live, but right to live with dignity. Now what happened that in Aruna Sonbag case, her friend filed the petition, but that petition was denied. But later on, after 7 years, in 2018, finally, in common cause case, Supreme Court allowed euthanasia. But there are two kinds of euthanasia: active euthanasia and passive euthanasia. Anyone can tell me the difference? Right. You have to administer any medicine or injection from outside. Now you say that we all are living, we all are taking breath. This is our natural life. This is the natural way of life. Now, if I go into a state where I am not able to breathe, but for my breathing, I have to be put on ventilator. हमें ventilator पे रखा गया. That is what external life support system. Naturally, I had lost my capacity to breathe. But this is the ventilator which is forcing me to breathe and I am living. But if you remove that external life support system, naturally I will die, right? So in that case, removal of external life support system amounts to passive euthanasia, okay? But naturally I am taking my breath, but I am terminally ill, brain dead हो गया हूँ मैं, I am not responding to anyone, कोई मुझसे बात करने आ रहा है, मैं उससे बात नहीं कर पा रहा हूँ, वॉशरूम तक उठ के नहीं जा पा रहा हूँ, life has become hell, but naturally I am living. If you leave me for 4 days, still I will survive without any external support. In that situation, if you give someone injection or give someone any medicine, he will die. That is called active euthanasia. So in this case of 2018, though Supreme Court allowed euthanasia in India, but only the kind of passive euthanasia was allowed, not the active euthanasia. And that also there, if you read newspapers, you will find one concept of living will. Living will क्या होता है? तो यहाँ पे जो आपने बात बोली, कोई भी इंसान अपने होशो हवास में, तो दिस होशो हवास means his mental state is very important. If I am signing a living will that I am fully fit now, but in future if I becomes terminally ill or I go into a persistent vegetative state or if I go into coma, do not spend money on my medical treatment, simply give me euthanasia. While signing this will, I should be of major age, that is of course 18 years, I should be fully mentally fit, I should be in the state of giving consent, right? तो कानून की भाषा में कंसेंट कौन दे सकता? जो मेंटली फिट हो, जिसपे किसी तरह का फोर्स यूज नहीं किया जा रहा हो, नो कोअर्शन इज बीन यूज्ड ऑन हिम एंड he is of a major age, that is above 18 years of age. So any such person can sign a document that is called living will, and if that person goes into a state, euthanasia can be granted to him, of course after following certain safeguards. What about those persons who did not sign a living will? Are they not eligible to get euthanasia? They are also eligible to get euthanasia, but in that situation a medical board is constituted, and that medical board will determine whether the person, the patient should be granted euthanasia or not, right? So answer to this question is common cause versus Union of India. In Aruna Sonbag, though this is a very important case if you read about euthanasia, but court has rejected euthanasia as a right of anyone. It was accepted as a right of anyone in common cause, right? Hanji. 80. Question number. C, it is C. In question number, this is C. C is the correct answer. Which of the following is true about the defamation laws in India? Defamation is also of two kinds, civil and criminal. The distinction remains in the nature of justice which is given. In civil defamation, you can claim only compensation. In criminal defamation, what happens with Rahul Baba happens usually, right? So you are sentenced. Okay. So section 499 and 500 of the Indian Penal Code deals with both civil and criminal defamation. Criminal defamation is punishable with an imprisonment of 7 years. In Subramaniam Swamy versus Union of India, Supreme Court upheld the constitutional validity of 499 and 500, and D is none of the above. C is true or false? We have to find a true statement. Only one will be true or none will be true. 499 and 500, these are the criminal laws. They do not deal with civil defamation, right? Civil defamation is dealt in torts, law of torts, right? So this is false statement. It deals with the criminal defamation. Criminal defamation is punishable up to an imprisonment of 7 years. This is also false. And this happens in the Subramaniam Swamy versus Union of India. Supreme Court upheld the constitutional validity that yes, defamation is constitutional. It is not ultra vires to the constitution. So answer shall be C. C is true. Which of the following parts or the section of constitution indirectly provides for the freedom of press? Though the word freedom of press is not mentioned in the constitution, but you can interpret from the various provisions of our constitution. What are they? Among the given fundamental rights, preamble, schedule 6 and schedule 10. You know about all the 12 schedules in India, what they deal for? ठीक है, तो बताओ आंसर. Where it is written in preamble? Liberty of expression, है ना? In the fundamental rights, article 19(1)(a). So in the fundamental rights and preamble, you find the concept of freedom of press. Schedule 6 is related to autonomous district council, the 4 states, and schedule 10 is related to anti-defection law. Our answer is 1 and 2. Consider the following statements about the Supreme Court's verdict in Anuradha Bhasin and others versus Union of India. This is a case, Anuradha Bhasin versus Union of India case. This is important one, and it was in pretty much in news when Jammu Kashmir was divided into 2 union territories. So there was internet shutdown for a continuous period of more than 100 days, right? So this case was of that era, right? But in this regard, we have to consider certain statements and then see access to internet was declared as a fundamental right. So firstly, say, is internet access of kind of recognized fundamental rights in India? It is recognized as a fundamental right, but is it recognized under Anuradha Bhasin case or not? No. It was recognized prior to Anuradha Bhasin case itself. So there is a case of state of Kerala, Fahima Sareen versus state of Kerala. Fahima Sareen versus state of Kerala. So though this is a case of 2019, here itself Supreme Court recognized that internet access is a kind of fundamental right in under the Constitution of India. Now relying upon this case, this lady filed a case in the Supreme Court that yes, people in the Jammu Kashmir are suffering from internet shutdown and this is the violation of one of our fundamental rights. So after this case, the 2G internet surfing at 2G speed was allowed in Jammu and Kashmir. तो वो 2G का बैन वहाँ से हटा लिया गया था. Thereafter, there was another case by professional media trial case ऐसा कुछ बोलते हैं उसको. In that 4G was also restored there, right? So yes, internet is a kind of fundamental right. This was recognized way back a year ago, not too back in 2019. This Aruna Bhasin case is of Anuradha Bhasin case is of 2020. Okay, it happened during the time of Jammu Kashmir. So first statement shall be false. But can internet is your fundamental right? But can government ban or restrict the use of internet or not? Yes. So none of the fundamental rights are absolute. Right to access the internet is also not absolute. Government can stop for the time being, and government can restrict also, but government needs to show proportionality that yes, I am banning the internet because the issue, the threat to the security of India is this much big. हर बात पे आप security of India बोल के internet नहीं बंद कर सकते. Government needs to show. So there is a test of proportionality. That order of banning the internet or restriction upon internet needs to pass this doctrine of proportionality. So this statement shall be true. Our answer shall be B. Consider the following statements about the freedom of profession mentioned under Article 19(1) G of the Constitution. Freedom of profession. हमारे पास सारे फ्रीडम है, एक व्यापार करने की स्वतंत्रता भी है, दैट इज अंडर 19(1). देयर आर 6 काइंड, बट बीच में 19(1) F is omitted, that related to right to property. ठीक है. The right is available to both citizens and foreigners. The government is empowered to enforce complete monopoly for itself on certain professions. Second is true. What about the first one? False. We have marked up there are 5 fundamental rights: 15, 16, 19, 29 and 30 only available to the citizens. Okay. So this one is false, this one is true. We have to find correct B, right? Prohibition of dance bars, it happened in Bombay. So dance bars may lead to violation of which of the fundamental rights of dance bar girls? Dance जो जहाँ पे होता है डांस बार्स वगैरह, इट्स वेरी पॉपुलर इन बॉम्बे. नाइट लाइफ वहीं का ज़्यादा है. हमारे दिल्ली में तो 10 बजे के बाद दिल्ली पुलिस घूमने लगती है. ठीक है. तो व्हाट आर्टिकल इट डज इट इम्पैक्ट? वन इज फ्रीडम ऑफ प्रोफेशन, सेकेंड प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी. Which of these rights are affected if there is a blanket ban which is imposed upon dance bar? Both freedom of profession and personal liberty, both are hampered. So our answer is C. Which of the following Supreme Court verdict deals with the right to privacy? I am not asking about in which case Supreme Court has declared right to privacy as a fundamental right. It is which of the following Supreme Court verdicts sometime or other have dealt with the issue of right to privacy. इनमें से कौन कौन से ऊपर प्राइवेसी की चर्चा करी है सुप्रीम कोर्ट ने? हमारे जो ऑप्शन है एमपी शर्मा केस 1954, खड़ग सिंह केस 1962, गोविंद वर्सेस स्टेट ऑफ एमपी 1975, जस्टिस के एस पुट्टुस्वामी वर्सेस यूनियन ऑफ इंडिया. ये तो आपको पता होगा, दिस इज पॉपुलर. व्हाट अबाउट द अदर 3? इन सब में सुप्रीम कोर्ट ने कहीं ना कहीं प्राइवेसी की बात की है, बट द केस पुट्टुस्वामी केस इज वेरी इंपॉर्टेंट. इट इज वाई बिकॉज इन ऑल दीज केस, इवन इन द खड़ग सिंह केस, खड़ग सिंह में यूपी पुलिस वाज कैचिंग वन क्रिमिनल, तो उसके बेडरूम तक सर्विलेंस लगाया हुआ था. ठीक है. यूपी पुलिस का आजकल कोई तोड़ नहीं है. So in all these cases, Supreme Court ruled that okay, right to privacy is your right, but it is not protected by the Constitution. This notion of giving protection to privacy started, it was declared by Puttuswamy case. It started from 1 or 2 years ago. वो थोड़ा पहले ही डिस्कोर्स में आ गया था. But this case earlier in 1950 till 1975 till the emergency period. इमरजेंसी पीरियड के पहले एक और बहुत इनफेमस केस है हमारे एडीएम जबलपुर केस. इट इज हाईली क्रिटिसाइज्ड. दैट रूल दैट ड्यूरिंग द इमरजेंसी हेबियस कॉर्पस विल आल्सो बी सस्पेंडेड. दैट इज आल्सो नोन बाय द नेम हेबियस कॉर्पस केस, है ना. राइट टू लाइफ भी आपकी छीन ली जाएगी, आर्टिकल 21. दैट वाज वर्डिक्ट गिवन इन द एडीएम जबलपुर केस, बट बाद में उसको ओवरटर्न कर दिया गया. राइट. सो ऑल दिस केसेस डील विद द issue of right to privacy, but right to privacy was guaranteed as a fundamental right in the case Puttuswamy case finally, and it opened the doors for various other discussion about recognition to transgender, self-determination of sex, LGBT judgments. All this opened only after the case Puttuswamy case, because until and unless you give right to privacy as your fundamental right, how can you say that someone has right to determine? अपना उनका सेक्सुअल ओरिएंटेशन क्या है, ठीक है। आधार वाला इशू भी इसके बाद, and this is also one of the outcome of the privacy only, the data protection bill. So earlier there was a data protection bill, और data protection bill के ऊपर UPSC has asked a question also that we are in making of data protection bill from 3-4 साल तो लगे गए आराम से, but where have we taken our general data protection rules, GDPR, from which country? European Union. This was the previous year question, पहले पूछा गया है, आई थिंक 2017 या 18 में. So our GDPR has been taken from European GDPR, but recently government withdrew the data protection bill and it has introduced a fresh bill in the November October, I think पिछले साल 2022 में. तो उसके ऊपर 2-3 क्वेश्चन है. One is, which of the following is the nodal ministry for the preparation of digital personal data protection bill, right? Question number 88. Any answers? मिनिस्टर ऑफ हेल्थ एंड फैमिली वेलफेयर तो हटा दो, साइंस एंड टेक्नोलॉजी को कोई काम ही नहीं करना इस देश में. मिनिस्ट्री ऑफ होम अफेयर्स, बिजी मैन. एंड मिनिस्ट्री ऑफ इंफॉर्मेशन, मिनिस्ट्री ऑफ इलेक्ट्रॉनिक एंड इंफॉर्मेशन टेक्नोलॉजी, डी फॉर दिल्ली, मीटी. व्हाई नॉट मिनिस्ट्री ऑफ होम अफेयर्स? हाँ, बिजी मैन. ओके, राइट. आंसर इज राइट बाय द वे. इट इज मिनिस्ट्री ऑफ Electronics and Information Technology is the nodal ministry for it. Now, personal data protection law can contribute to which of the following? Personal data protection law can contribute to which of the following? Effective implementation of right to privacy. This is very much the most relatable outcome. Zomato में आपका डेटा है, क्रेडिट कार्ड स्टोर है, टोकनाइजेशन करो या कुछ, जिस दिन लूटेंगे तो सब लूट लेंगे. It happened with the Zomato. The credit card numbers of around 1 lakh users were compromised in Zomato. हम लोग जो बोलते हैं 2 मिनट में ऑर्डर करिए, एकदम कार्ड का डिटेल स्टोर करके रखिए कि जिस दिन जोमेटो का सर्वर कॉम्प्रोमाइज हो, आपका कार्ड नंबर भी जाए दुनिया के पास और आप शॉपिंग नहीं कर रहे हो, आपकी वजह से कोई दुआ देगा आपको, ठीक है. तो फर्स्ट इज इफेक्टिव इंप्लीमेंटेशन ऑफ राइट टू प्राइवेसी, प्रोटेक्शन ऑफ नेशनल सिक्योरिटी. द बिगेस्ट थ्रेट टू आवर प्राइवेसी फ्रॉम द साइड ऑफ गवर्नमेंट इज द नेशनल सिक्योरिटी. गवर्नमेंट नेशनल सिक्योरिटी के नाम पे टेलीफोन टैप करा सकती है. तो दिस टेलीफोन टैपिंग कहाँ से आता है? ये देयर इज अगेन कॉलोनियल लॉ, द टेलीग्राफ एक्ट, उसमें सेक्शन 5 में प्रोविजंस हैं टू टैप द टेलीफोन. ये मूवी, ये वेब सीरीज किसी ने देखी है? बिहार के एक IPS ऑफिसर पे आया था, लोढ़ा खाकी. उसमें क्रिमिनल को पकड़ने के लिए नया नया सेलुलर टेक्नोलॉजी पे पैरेलल लिसनिंग फैसिलिटी. मेरे को आज तक समझ में नहीं होता है कि नहीं होता है. ये नहीं होता है सच में? वहां फोन बजेगा, यहाँ ही बजेगा. नहीं, यू कैन ट्रेस, बट इन दैट इट वाज डिपिक्टेड कि इफ आई एम हैविंग अ फोन, यू कैन आल्सो साइमल्टेनियसली लिसन व्हाट आई एम टॉकिंग, दैट टू इन द सिम कार्ड. इट कैन बी डन. बाबा रे, बंद करो. Preventing unauthorized use of personal data for political and commercial purposes. Basically, all of these can be the one of the outcomes for if we implement this our data protection bill. अच्छा, टेस्ट सीरीज में या फिर प्रैक्टिस के समय one of the motives of giving this all of the above option just to give you the awareness about the fact. यूपीएससी में all of the above नहीं मान के चलना है, पीसीएस में होता है, ठीक है. यूपीएससी वाले जानबूझ के ना डालते हैं ऐसा all of the above option. Consider the following statements about the DNA technology used in Application Bill 2018. It is aimed at expanding the application of DNA-based forensic technologies, restrict the use of DNA testing only for the identification purpose. It provides that the collection of DNA samples can be only made after the consent of the accused. A is true. This statement number 1 is true. It restricts the use of DNA testing only for the identification purpose. Why it is false? Huh? But the purpose is for identification only. You will match someone's DNA with the database and then you will say it is his DNA. Database तो हमने बना लिया, बस database का purpose क्या हुआ? For identification only. जैसे एक मेरा डीएनए है, मुझे मैच करना है कि ये डीएनए उससे मिल रहा है कि नहीं, इसने रेप कमिट किया है कि नहीं। आई गॉट अ सर्टेन सीमेन सैंपल, जब उसका हेयर सैंपल मिला क्राइम सीन से, नाउ आई नीड टू मैच विद दैट ऑफ अक्यूज्ड। तो हमने एक डेटाबेस प्रिपेयर किया हुआ है, यहाँ डीएनए का जो स्ट्रक्चर आया, आई विल फेच फ्रॉम द आवर डेटाबेस, आइडेंटिफाई हो गया, यू आर कल्प्रिट, राइट। तो आइडेंटिफिकेशन पर्पस के लिए यहाँ पे आप इसका मोटिव ये समझो कि डीएनए इज अ वेरी रिस्की टेक्नोलॉजी। आप बगल में घूम रहे होगे, आपका एक हमशक्ल भी घूम रहा होगा, राइट। फॉर दोज ऑल दोज पर्पसेस अंडर दिस एक्ट डीएनए technology use and adoption bill 2018 we do not allow for cloning purposes, for all those purposes it is restricted for identification only, right, it is restricted for identification only. But the third option that it is saying it is only for the consent, it can also be directed by the courts upon the orders of the court, right. So third statement happens to be false, right. So we have 1 and 2 only as the correct option, right. Marketplace of idea doctrine was enunciated in which of the following Supreme Court verdict? Anyone from political science optional? PSIR optional है किसी का? नहीं? आपका है? आप बताओ आंसर। No idea. What is marketplace of idea doctrine? Marketplace of thoughts क्या होता है? Marketplace of ideas. Actually, this is based upon the use and our society which is more free for ideas. So there, John Mill has given this concept. John Mill कहते हैं कि in the society where people can exchange their ideas freely, there is lesser restriction on thought. That is indeed a society that is rather a marketplace of ideas. Market में आप क्या करते हो? Exchange करते हो. So if you exchange the ideas, because if your society is free enough, there is less restrictions upon your freedom of speech and expression. So John Mill, while in his book Political Theory, he has discussed about this doctrine. सुप्रीम कोर्ट ने किस जजमेंट में इस डॉक्ट्रिन की चर्चा की थी? सबसे पहले, इफ यू कैन फिल्टर आउट विच ऑफ दीज केसेस टॉक्स अबाउट द फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, देन यू विल बी एबल टू रिलेट. So it is Shreya Singhal versus Union of India. Shreya Singhal versus Union of India. Consider the following statements about the recent order by Government of India authorizing 10 institutions to track content generated, received or stored in any computer belonging to any individual or organization for this purpose specified in section 69(1) of the Information Technology Act. सिंपली कहानी कट शॉर्ट ये है कि गवर्नमेंट ने एक ऑर्डर पास किया कि जितने भी इंटेलिजेंस एजेंसी है वो 10 दे कैन ट्रैक वट एवर यू आर डूइंग. यहाँ से ईमेल भेज रहे हो, दे कैन ट्रैक इन बिटवीन. हालांकि ईमेल एंड वट एवर द कम्युनिकेशन वी आर यूजिंग वो थोड़ा ट्रैक करना बीच से पॉसिबल नहीं होता है. दैट इज बेस्ड अपॉन एनक्रिप्शन. एनक्रिप्शन एक एल्गोरिथम को यूज करके वट एवर यू आर सेंडिंग, हेलो मिस्टर हाउ आर यू डूइंग, तो हेलो विल बी ब्रोकन इनटू अ पैकेट, अलग अलग आएगा. नाउ हेलो विल बी पुट इनटू अ एनक्रिप्टेड लैंग्वेज, है ना, साइफर लैंग्वेज, साइफर टेक्स्ट बोलते हैं उसको. देन वो एक की से लॉक होगा and the actual person who is supposed to be the receiver, he will be having the public key of that. Unless and until both the keys will match, वो डिकोड नहीं होगा. तो अगर abc@gmail.com के लिए मैसेज भेजा गया है तो इन हिज ब्राउजर देयर विल बी अ की रिलेटेड टू इट, उस पे पहुंचेगा, देन ओनली ही विल बी एबल टू रीड. हाउएवर ये एनक्रिप्शन कौन मैनेज कर रहा है? द सर्विस प्रोवाइडर. इफ गवर्नमेंट पुट्स कि नहीं आपको इन कंपनीज को बीच में ट्रेस करने का ऑप्शन देना है, दे विल बी बाउंड टू, बिकॉज दे आर बाउंड बाय द रूल्स ऑफ द गवर्नमेंट. जैसे बीच में व्हाट्सएप ने एक ऐड चलाया था, दादी जी हैं देख रही हैं, अपनी नाती से बात कर रही हैं, इट इज बिटवीन ओनली यू एंड मी. दैट वाज अ काउंटर टू द गवर्नमेंट ऑर्डर्स. द गवर्नमेंट इन द वेक ऑफ फेक न्यूज, गवर्नमेंट ने बोला था कि आप मुझे बताओ मैसेज का सोर्स कहाँ है. तो व्हाट्सएप ने लोगों के अगेंस्ट, लोगों के बीच में कैंपेन चला कि देखो हम इतने सिक्योर हैं, हम किसी को नहीं बताते हैं. राइट, पर्पस यही था कि आप जानो कि हमारा व्हाट्सएप का कम्युनिकेशन है वो एंड टू एंड सिक्योर्ड है, कि लोग जानेंगे तो थोड़ा एक माहौल बनेगा व्हाट्सएप के लिए. WhatsApp will be exempted from giving the details. ठीक है, यहाँ पे है द ऑर्डर वाज इशूड बाय मिनिस्ट्री ऑफ डिफेंस, इट ऑथराइज 10 गवर्नमेंट इंस्टीट्यूशंस फ्रॉम बोथ सेंट्रल एंड स्टेट लेवल्स, विच ऑफ देम आर करेक्ट? हाँ, बी इज करेक्ट, डी नीदर, मिनिस्ट्री ऑफ डिफेंस नहीं, मिनिस्ट्री ऑफ होम अफेयर्स एंड नॉट द स्टेट गवर्नमेंट। बच्चों वाले सवाल है, वो ऊपर का एक्सप्लेनेशन देख के थोड़ा हैवी हो गया था, है ना। Alliance 8.7 in news recently refers to a global partnership to fight human trafficking, eliminate child labor, eliminate sex selective abortion, and none of them. Alliance, क्वेश्चन नंबर 93, इसका क्या आंसर है बताओ? एलिमिनेट चाइल्ड लेबर, एलिमिनेट चाइल्ड लेबर। जस्ट टर्म इन को न्यूज में दिखा था, इफ यू वांट द इलेबोरेट फिर वो मैं कल आपको दूंगा, क्योंकि इसको मैंने उठाया, इट्स जस्ट ग्रुप ग्लोबल लेवल पे पार्टनरशिप टू एलिमिनेट द चाइल्ड लेबर। ठीक है, डिटेल में अगर आपको चाहिए तो फिर मैं आपको कल बता दूंगा। ये करंट अफेयर्स का एक्चुअली नॉट डायरेक्टली रिलेटेड टू स्टैटिक ऑफ द पॉलिसी। Consider the following statements about the CAG, Comptroller and Auditor General of India. One is to audit all expenditure from the Consolidated Fund of India and of each of the state and union territory having a legislative assembly. Second, to audit all transaction of the union and of the states relating to contingency fund and public accounts. Third, to audit all trading, manufacturing, profit and loss accounts and balance sheet and other subsidiary accounts kept in any department of the union or of the state. All state क्या कर सकता है? CAG audit, union territory क्या कर सकता है? CAG is a functionality, it is created under article 148, their powers and functions have been given under article 149. तो दो आर्टिकल है which talks about the Comptroller and Auditor General of India. Earlier the CAG was the person who has been given the power to audit the account and also he was given the functions to keep the book of accounts for the union government also and for the state government, इसलिए दो नाम दिया उसको। कंट्रोलर मतलब कीपर ऑफ द बुक्स ऑफ अकाउंट्स एंड ऑडिटर, ऑडिटर ऑफ द accounts. But this function of keeping of the books and keeping of the accounts for the union government is now withdrawn from the CAG. He is only auditing the accounts of the union, but he is keeping the books of account of the states and also auditing the accounts of the state government, right? He can audit also the accounts of the public sector undertakings also. CAG public sector undertaking के भी accounts की audit कर सकता है और for any other corporation जिसकी direction उसको president देंगे, ठीक है? So all these statements are true in this question. Our answer is D. Which of the following is or are the eligibility criteria to contest election for the office of president? He must be a citizen of India. He must have completed the 30 years of age. Must be eligible to become the member of the Lok Sabha. Should not be holding any office of profit under the government of India. Only one is incorrect, that is 35 years of age it should be. Here it is written 30. So our correct answer is 1, 2 and 4, that is B. Oh, sorry, 1, 3 and 4. 2 is false. 2 is false. Must have completed 35 years of age, rather not 30 years of age. Which of the following organization releases World Freedom Index? कौन सी ऑर्गेनाइजेशन निकालती है? Reporters Sans Borders or Reporters Without Borders. This is the organization. Now in the parliament recently, government has submitted a report that they do not agree to the what is finding of this organization, क्योंकि इंडिया को बहुत नीचे रखा है, right? And India has been declared as one of the deadliest country for the reporters. Exact अगर रैंक आपको चाहिए तो मैं बता देता हूँ. What is the rank? India has been ranked 150 out of 180 countries in this Freedom World Press Freedom Index. ठीक है. Answer is B, Reporters Without Borders. Which of the following statements is correct about the election process of the president in India? Which of the following statement is correct about the election process of the president in India? President is elected by an electoral college consisting of MPs of only the lower house of the parliament and MLAs of the state and of Delhi and Pondicherry. It is false statement because it consists members of both the houses, lower house and upper house of the parliament, right? Second, the votes are weighted, their values determined by the population of each state as per the 1971 census. अच्छा, ये तो ट्रू लग रहा है, बाकी को भी कंसिडर करते हैं. The nominated members of Rajya Sabha, Lok Sabha and the assemblies and the members of legislative council are the part of electoral college. Now, firstly, none of the nominated members will take participation in the election of the president, but the nominated members of the Rajya Sabha only participates in the, not the legislative council. उनके nominated members या फिर legislative assembly के elected हो या nominated हो, कोई भी removal में participate नहीं करता president के, right? Article 58 of the Indian Constitution provides for an election to fill a vacancy caused by the expiration of the terms of the president shall be complete before the expiration of the term of the president. हाँ, क्यों wrong है? हाँ, term 5 years का है, 6 महीने के अंदर करना होगा. That is different thing, but it is talking that Article 58 of the Indian Constitution provides for an election to fill a vacancy caused by the expiration of term of the president shall be completed before the expiration of term or not. Article गलत है. It is the article which is wrong, है ना? तो यहाँ पे जो आपका करेक्ट आंसर था वो था बी. Which of the following statements about the doctrine of basic structure is not correct? It is a form of judicial review that is used to test the legality of any legislation by the court. It was evolved by the Supreme Court in the 1973 landmark ruling in the Keswananda Bharti versus State of Kerala. It checks the constitutional amendment to ensure the amendments does not dilute the fundamental of the constitution itself. The parliament can either amend or destroy the basic structure. Last वाला बिल्कुल ही बकवास गलत. पूरा बेसिक स्ट्रक्चर की मेहनत ही बर्बाद कर दी इसने तो. ये भी नहीं चल रहा मेरे से. चलो, this last one, the D is incorrect. All the other three are correct as per basic structure doctrine. 99. Consider the following statements. In the landmark 2013 ruling of the Lily Thomas versus Union of India, Supreme Court struck down the section 8 subclause 4 of the Representation of People Act as unconstitutional. अब इसका background थोड़ा समझिए. This section 8(4) why I have directly written not कि क्या उसमें है, because it is into the news due to Rahul Gandhi case, right? क्या है वो? So in section 8 subclause 4 it was mentioned that any legislator, ideally क्या होता है कि any legislator, either the part of the MLA, member of legislative assembly or an MP who has been sentenced to more than 2 years shall be disqualified, right? But as per section 8(4), 3 months time gap was given. So until and unless after the declaration of the sentence, 3 months have passed where the particular legislator who has got the sentence have appealed and his appeal has been dismissed, 3 महीने से पहले उसको डिस्क्वालिफिकेशन नहीं किया जा सकता था. बट इन द लिली थॉमस केस इटसेल्फ सुप्रीम कोर्ट struck down this provision as unconstitutional. So now the situation is, as soon as the person has been sentenced to jail, he is eligible to be disqualified, and this is what happened in the Rahul Gandhi case. तो लोग ये बोल रहे थे 3 महीने का टाइम देना चाहिए था. क्यों देंगे जब ये सुप्रीम कोर्ट ने डिस्क्वालीफाई अनकॉन्स्टिट्यूशनल कर दिया है? तो दिस फर्स्ट स्टेटमेंट इज ट्रू. First statement is true. The 10th schedule of the Constitution provides for the disqualification of a member on the grounds of defection. True. 10th schedule provides for the anti-defection regime. That is, if any person switches his party or any independent person joins the party after election, तो वो disqualify होने के लिए liable है. Both the statement here are true. अच्छा, और statement है. Article 102 subclause 1 provides for the disqualification of members of parliament on the grounds which include holding office of profit, being unsound mind or insolvent, or having or not having a valid citizenship. So mainly it is talking about the eligibility of becoming the members. अब बताओ ये सही है या गलत है? हाँ, तो ऐसा ही एंटी एलिमिनेशन वाला ऑप्शन है. ऑल थ्री आर करेक्ट. With reference to the recent amendments in the Prevention of Money Laundering Act, consider the following statement. Finance Ministry has amended the money laundering rule to incorporate more disclosure for non-governmental organizations by reporting entities like financial institutions, bank, companies or financial intermediaries. Second is, it has defined a politically exposed person under Prevention of Money Laundering Act in line with the recommendations of G20 Anti-Corruption Working Group. दो स्टेटमेंट है, राइट. पहला कहता है कि इसने ये किया, सही है गलत. नाउ अगर किया तो क्या किसके कहने पे किया? फर्स्ट स्टेटमेंट इज ट्रू. नाउ कंसिडर अबाउट द सेकंड स्टेटमेंट. हैज इट डिफाइंड द पॉलिटिकली एक्सपोज्ड पर्सन? इट हैज डिफाइंड द पॉलिटिकली एक्सपोज्ड पर्सन. हु आर द पॉलिटिकली एक्सपोज्ड पर्सन? The persons who have been given certain important public functionalities, like मिनिस्टरशिप में कुछ दे दिया, तो उन लोगों को कुछ एक्स्ट्रा डिक्लेरेशन करने की बात इंक्लूड की गई है प्रिवेंशन ऑफ ऐसी एनजीओज या फिर ऐसी एंटिटीज जो उनसे फंडिंग लेती हैं. तो पॉलिटिकली एक्सपोज पर्संस को भी पीएमएलए के नए रूल में इंक्लूड किया गया है, बट नॉट द डोमेस्टिक पॉलिटिकली एक्सपोज पर्सन. तो दिस रूल टॉक्स अबाउट द फॉरेन पॉलिटिकली एक्सपोज पर्सन. First thing. Secondly, the same has been done not based on the recommendation of G20 Anti-Corruption Group, but based on the recommendation of Financial Action Task Force, FATF. ठीक है? FATF. Only one is correct, second is false. Which of the following statements with reference to safe harbor recently seen in news are correct? What is safe harbor? Intermediaries will be protected. So suppose that I am Instagram, I am Facebook. Now there is one user XYZ. He is promoting obscene content on the Instagram. Shall I be held responsible for that? No. I have been given the safe harbor, meaning that if any person who is doing certain act which is illegal on the online platform, that platform is not guilty about that if they have done certain due diligence behind that. अगर online platform खुद ही negligent है, they will also be held liable for that. But if online platform is properly following all the regulations, they are following all the reporting mechanisms, and even then certain person is abusing the online platform or doing certain illegal activities through that online platform, they shall be exempted from any legal liability. This is called safe harbor, right? So now in context of safe harbor, please consider it is prescribed under section 79 of the Information Technology Act as a legal immunity that online intermediaries enjoys against the content posted by users on their platform. Secondly, the concept originally came from Section 230 of United States Communication Decency Act, which has been termed one of the foundational law behind the modern internet. ठीक है? पहला स्टेटमेंट एक्सप्लेन तो मैंने सही कर दिया. Whether it has been provided under Section 79, it is correct, right? Is the Section 79 of the Indian IT Act inspired from the US? It is correct. So both these statements are correct. Sadiq Ali case, which was recently seen in news, relates to dispute between the political party, interreligion marriages, adultery and citizenship rights. Sadiq Ali case. A is the correct. It is related to the disputes between the political party factions. So what happened? Recently there was a dispute between Shiv Sena two wings that the party belongs to whom. So this has to be decided by the Election Commission of India. So Election Commission of India, while deciding this, it relied upon the Sadiq Ali case judgment, which was given by the Supreme Court way back 30 years ago, that whenever there is such a dispute, party kiske paas hogi, it has to be decided based on the majority of all the members, majority of the party workers, majority of the legislator who has been elected from the party. So किसी भी political party में there is a two party concept. एक political party में एक ही party नहीं होती है, दो party होती है. One is political party and another is legislature party. So suppose that BJP is a party of having like say millions of members होंगे उसके, but everybody is not a legislator out of that. Only selected few are the legislator, be it in the state assemblies or be it in the parliament, right? So only those persons out of the BJP who has been elected or directly or indirectly किसी भी legislature में किसी भी house of the legislation में है, then they will be called, their group will be called legislature party. तो जब पार्टी की डिस्प्यूट होती है, एक पार्टी में दो रिफ्ट होता है, तो अगर आप सिर्फ मान लो कि शिवसेना है, देयर आर हार्डली 30-40 एमएलएज, 3-4 एमबीए होते हैं उनके, और उनके पास 2-3 लाख पार्टी वर्कर्स हैं. व्हाट इफ एवरी पार्टी वर्कर इज सेइंग कि मुझे उद्धव ठाकरे के पास भेज दो, और 30 लोग बोल रहे हैं नहीं मुझे बीजेपी के पास भेज दो, तो किसके पास जाएगा? अगर सिर्फ बीजेपी के पास भेज देते हैं ओनली ऑन द बेसिस ऑफ दिस लेजिस्लेटर पार्टी, डोंट यू थिंक इट इज एन इनजस्टिस टू 1 लाख 2 लाख पीपल हु आर द पार्टी वर्कर्स? तो सादिक अली केस में सुप्रीम कोर्ट ने बोला था कि व्हेनेवर सच फैक्शन इज क्रिएटेड बिटवीन वन पॉलिटिकल पार्टी, द आइडेंटिटी ऑफ द पार्टी दैट इट शुड बी गोइंग विथ विच ऑफ द फैक्शन should be decided keeping in mind both the legislator portion and also other party workers. दोनों की आप वे करके कि कौन किस में ज्यादा है, तब you will have to decide. So based upon this, election commission decided that the Shiv Sena bow and arrow symbol should be allocated to whom? The Shinde group, right? So this case is related to dispute between the political parties. Now 103, consider the following statements. The Prohibition of Child Marriage Act 2006 says that child marriage are illegal and void. Second, Jaya Jetli committee submitted a report stating that the child marriageable age for women should be increased from 18 to 21 years of age. Which one of the above statement are incorrect? Right? इनमें से कौन सा statement है जो incorrect ढूंढना है? First statement is saying, according to this act, child marriages are illegal and void. दो term है. Now you have to know the meaning of both. Illegal means which has been prohibited by the law. Void means which is not valid. Which is not valid. But law के sense में there are confusing terms. ये लिख क्यों नहीं रहा? One is void and another is voidable. Void मतलब which is ineffective from the very beginning. Void ab initio बोलते हैं इसको. Ineffective from the very start. Suppose I'll give you one example that there are two persons X and Y. X is a male of 23 years of age. Y is a female of 17 years of age. Right? दोनों की शादी करा देते हैं. मैं नहीं कराऊंगा. चाइल्ड मैरिज के अंदर आ जाएगा. बट किसी ने करा दी. Right? So both, this is a case of child marriage. अब in that situation, it is illegal. The person who made this marriage to happen, इनके माता पिता, दोनों के माता पिता, the person who was arranging all the things, जो बीच का नहीं होता है, अगवा, हाँ, mediator. So he is also liable to get punished, क्योंकि इन्होंने एक ऐसा काम किया है which is breaching the law. This is illegal. They may be sentenced. हाँ, these peoples वही मैं बात कर रहा हूँ. इन these peoples में जो फीमेल है, सॉरी मेल है, इसके ऊपर भी केस बन सकता है, but in not in all the situations. Not in all the situations. What if the material fact was concealed from this person that the child girl is not minor? अगर इससे fact छुपा दी, तो certain situation, but he was also knowing willfully and intentionally, then he went on to marry with a child. he is also liable to be punished, right? But in that situation, what about this marriage? Is this marriage void? It is voidable. Void का मतलब होता कि स्टार्टिंग से इसको अमान्य कर देते हैं. It will have no effect from the very beginning. But in this situation, what will happen? Let this child, the female turn major. If she wishes that I shall continue with the marriage will get continued. If she wishes that the marriage should be dissolved, the marriage will be dissolved. So in this situation, under the Child Marriage Act, in case of any child marriage which has occurred, ideally it is the duty of the government, it is the duty of the state to prevent any kind of child marriage. But we know in Rajasthan, during a particular festival कोई 30 तरह का होता है, rampantly child marriage होता है, अभी भी 2023 में भी, right? So अगर कोई child marriage हो गया, then the option is at the minor party. शादी में 2 पार्टी होती है, एक ब्राइड और एक ग्रूम. तो इसमें से जो माइनर है अकॉर्डिंग टू द लॉ, यहाँ पे जो माइनर कॉन्सेप्ट है, इट इज 21 फॉर द मेल्स एंड 18 फॉर द फीमेल्स. चाइल्ड मैरिज का मतलब ये नहीं सिर्फ लड़कियों की ही चाइल्ड मैरिज हो सकती है, लड़कों का भी चाइल्ड मैरिज हो सकता है भाई. इट्स नॉट दैट ऑलवेज मेंस आर प्रोटेक्टेड, कभी कभी उन पे भी खतरा होता है, ठीक है. तो इफ एनीबॉडी इज अंडर एज, इट डिपेंड्स अपॉन हिम, इट विल बी voidable एट देयर इंस्टेंस. तो ऐसा कहना गलत होगा दैट द चाइल्ड मैरिज इज void. इट इज voidable. ओके. नाउ इट सेकंड से जया जेटली कमिटी सबमिटेड अ रिपोर्ट स्टेटिंग दैट द मैरिजेबल एज फॉर द वुमेन शैल बी इंक्रीज टू 21 years of age. ये अभी हुआ है. So this is correct statement, right? Only 2. Oh sorry, incorrect we have to find. Incorrect we have to find. Only 1 is incorrect. Minor after turning the major. अब इसमें फिर आपको होगा कि अब 1 साल के बीच में वो कहाँ रहेगी. द कस्टडी ऑफ द गर्ल चाइल्ड विल बी इंपॉर्टेंट. किसको दी जाती है, क्योंकि माँ बाप को तो दे नहीं सकते, उन्होंने चाइल्ड मैरिज करा दी. शी विल बी फर्दर प्रोन टू अब्यूज द नेक्स्ट गार्जियन, ऐसे करके. अच्छा, उसमें भी होगा इफ द नेचुरल गार्जियन ऑफ ए गर्ल चाइल्ड इज मदर नॉट द फादर. गार्जियनशिप की जब बात आती है तो फर्स्ट गार्जियन गर्ल चाइल्ड की वो मदर होती है. किडनैपिंग 18 साल के ऊपर के जेंट्स का किडनैपिंग नहीं होता, बट ए गर्ल मोर देन 18 years of age कैन स्टिल बी किडनैप्ड. ये थोड़ा सा पैट्रियार्की है हमारे लॉ में, दैट अ गर्ल हैज ऑलवेज बीन कंसिडर्ड एज ए सब्जेक्ट जिसके ऊपर किसी की कस्टडी या कमांड होगा. तो गर्ल इज नेवर कंसिडर्ड आउट ऑफ कस्टडी, बट मेल आवारा घूमते हैं कानून के हिसाब से. एनीवन, यू कैन ऑल्सो फाइल. अगर आपको लग रहा है कहीं चाइल्ड मैरिज हो रहा है, फाइल करो. पुलिस नहीं आती है तो फिर पुलिस के अगेंस्ट में फाइल कर दो. सच में कर दो. आपकी ड्यूटी होगी जब डीएम बन जाओगे तो चाइल्ड मैरिज बंद कराना. इट इज द ड्यूटी ऑफ द स्टेट, इट इज द लायबिलिटी ऑफ द स्टेट, एंड यू आर द मोस्ट बेसिक लेवल इंस्ट्रूमेंटलिटी ऑफ द स्टेट. राइट. विथ रेफरेंस टू आर्टिकल 356 इन द इंडियन कॉन्स्टिट्यूशन, विच ऑफ द फॉलोइंग इज और आर करेक्ट? आर्टिकल 356 एम्पावर्स द. अच्छा, ऐसा नहीं है कि फंडामेंटल राइट पढ़ रहे हैं तो खाली फंडामेंटल राइट पढ़ेंगे. आई एम सपोजिंग दैट इफ यू आर गोइंग टू अपीयर इन 2023, you would have at least one time referred book of polity. ठीक है. तो एक आधा क्वेश्चन रैंडम आ सकते हैं, बट इमरजेंसी हम अलग से टॉपिक फुल फ्लेजेड भी करेंगे. आर्टिकल 356 empower the president to withdraw to union the executive and legislative power of any state if he is satisfied that a situation has arisen in which the government of the state cannot be carried out in accordance with the provision of the constitution. इतना लंबा लिखने की वजह सिंपल ये भी लिखा हो सकता है, फेलियर ऑफ कॉन्स्टिट्यूशनल मशीनरी. Right. Second is whether the constitutional machinery has been broken down may be determined by the president only upon the receipt of the governor. Third one is according to the provisions of Article 356, president rule in a state can be imposed for 6 months and for a maximum period of 2 years. Maximum period of 3 years, every time 6 months. Right. Constitutional machinery has been broken or not, who can decide? President can decide, but there are various ways. If state government has denied to follow the mandatory directions of the union, अंडर 365 इट इज ऑल्सो अ काइंड ऑफ फेलियर ऑफ कॉन्स्टिट्यूशनल मशीनरी। तो उसमें भी हमारा आ जाएगा, इमरजेंसी लगाई जा सकती है, राइट। So we have to find incorrect statement. Third is incorrect, second is incorrect, first is correct. So our answer shall be C, 2 and 3. With reference to the President's address to Parliament, consider the following statements. In India, the practice of President addressing the Parliament was established after the promulgation of the Government of India Act in 1919. Second, Article 87 provides two special occasions on which President addresses a joint sitting. Third, in 1951, the first amendment to the Constitution made the presidential address an annual affair. How many times President address a joint sitting of Parliament? One is the start of the year, that is budget session se pehle. Second is press elections after have been conducted in the Lok Sabha. So before the first sitting of the, तो दो बारी वो करते हैं, दो बारी करते हैं. One is after the fresh election Lok Sabha has been elected, and second is every year. So third statement is correct. It is an annual affair. But क्या first amendment से आया है या नहीं? आया है. So this statement is true. Second is saying that Article 87 provides for two special occasions on which President addresses the Parliament. Right? So क्या है ये? True है. दो समय करते हैं. One, in India, the practice of President addressing the Parliament was established after the promulgation of Government of India Act in 1919. वो स्टेटमेंट सही है नहीं? प्रेसिडेंशियल एक्ट, उस समय प्रेसिडेंट को वाइसरॉय मान के चलिए. Presidential address means viceroy address. Is it true? It is true. So our answer is C, 1, 2 and 3. With reference to the joint parliamentary committee, अभी बहुत लोग डिमांड कर रहे थे अडानी के ऊपर. With reference to the joint parliamentary committee, consider the following statements. It is set up by the parliament for a special purpose, like for a detailed scrutiny of any subject or any bill. Recommendations of joint parliamentary committee are binding on the government. Third, it has members from both the houses but excluding the members from the ruling parties. True or false? Third one is false. Joint parliamentary committee means it is having members from both the houses of the parliament. This is why it is called joint. But ऐसा नहीं कि बीजेपी की members को नहीं मिलाएंगे तो opposition committee हो जाएगी. So it has members from both the houses of the parliament and still from both the parties, opposition and the ruling party. So this statement is false. The recommendations of joint parliamentary committee are not binding. However, they carry a very huge weight, but they are still not legally binding upon the government. It is set up by the parliament for a special purpose. वो तो एक अच्छा सा वेग सा स्टेटमेंट है. So which we have to find which are incorrect. Only 2 and 3 are incorrect. Answer is B. Consider the following statements. The writ of mandamus is available not only against the judicial authorities but also against the administrative authorities. Writ of mandamus. Second statement, the writ of prohibition is issued only against the judicial or quasi-judicial authorities. Mandamus is available not only against the judicial authorities but also against the administrative authorities. देखो एक केस है आई थिंक 1971 का. बिफोर दैट इट वाज ओनली इशूड अगेंस्ट द एडमिनिस्ट्रेटिव अथॉरिटीज. मैंडमस हम बोलते हैं, इट इज अगेंस्ट द एग्जीक्यूटिव. इट वाज ओनली इशूड अगेंस्ट द एडमिनिस्ट्रेटिव अथॉरिटीज. बट आफ्टर दैट केस mandamus has also been started to be used against the judicial authorities. So it may be used against both. तो ये स्टेटमेंट हो जाएगा हमारा false, right? The writ of prohibition is issued only against the judicial or quasi-judicial authorities. It cannot be used against ministers. It cannot be used against executive authorities. Prohibition is used against quasi-judicial or any tribunal kind of authorities. कोट करता नहीं फंडामेंटल राइट वायलेशन. जुडिशियल ऑथोरिटी also means the lower courts. It will include the lower courts, na? Mandamus is the order, so High Court can pass order against the lower courts, na? It is the power vested in the High Court, Article 227. हाँ, इसको देखिए, writ of mandamus, when can it be issued? If any fundamental right or legal right is violated by any authority, right? अगर वो एग्जीक्यूटिव है तो उसके अगेंस्ट हम मैंडमस इशू कर सकते हैं. दिस इज सो फार क्लियर. क्वेश्चन ये है कि जुडिशियल के अगेंस्ट यूज कर सकते हैं कि नहीं. अगर कर सकते हैं तो क्या ऐसा होता है हमारे देश में जब जुडिशियल अथॉरिटी भी राइट्स और फंडामेंटल राइट्स को वायलेट कर सकती है या नहीं? एग्जाम्पल देके बताता हूं मैं आपको. वी हैड डिस्कस द हायरार्की ऑफ कोर्ट्स इन इंडिया, राइट? लेट्स कंसिडर द हायरार्की ऑफ क्रिमिनल कोर्ट्स इन इंडिया. सुप्रीम कोर्ट टॉप मोस्ट, हाई कोर्ट, then you have sessions court, then you have additional session court, then you have assistant session court, CJM, JM class 1, JM class 2. This is the hierarchy. This hierarchy is based upon the power to issue the sentence. 1 year, 3 year, 7 years, any sentence they can issue. अब एक समझिए कि मान लीजिए एक मर्डर का केस है. The minimum sentence here is 10 years. What if it has been settled by a CJM court? Your legal right is violated then, है ना? आपका राइट वायलेट नहीं हुआ. What if a particular person has decided anything against you? मान लीजिए कि मैं जज हूं, आप एक केस लेके आते हैं अगेंस्ट सो एंड सो बिल्डर. I have a pecuniary interest in that project. I may be biased. So this is against the principles of natural justice, and still I goes on and sit to decide the case. Is your right to free and fair trial protected? Judge, see, it is against judgment वाला है, उसमें आप lack of error of jurisdiction और lack of jurisdiction के कारण आप certiorari और prohibition यूज कर सकते हैं. बट वाइल डूइंग सर्टेन थिंग्स आपका राइट होता है सर्टिफाइड कॉपी लेना. व्हाट इफ द कोर्ट आफ्टर पासिंग अ जजमेंट इज नॉट गिविंग यू? वो तो उसका एडमिनिस्ट्रेटिव फंक्शन हो गया ना. बट जुडिशियल अथॉरिटी ऑल्सो हैज एडमिनिस्ट्रेटिव फंक्शंस ना, है ना? As far as the armed forces are concerned, under the fundamental rights guaranteed under Article 14 and 19 of the Constitution, they are not available at all to them. Available to the armed forces but not to other forces. Available only at the discretion of the Chief of the Army Staff. Available only according to the law made by the Parliament. Their right to fundamental rights to the armed forces can be restricted. We have already discussed, I think, previous class, but it can be restricted only at the law made by the Parliament, right? So answer is D. Consider the following statement. The state under Article 12 of the Indian Constitution includes which of the following? Government and the Parliament of India, government and the legislature of the state, local authorities or the other authorities within which the territory, within the territory of India or under the control of government of India. All of these are included as the state for the purpose of Article 12. The same definition shall also apply for the purpose of DPSP, that is Article 36. दोनों के लिए स्टेट का डेफिनेशन अलग अलग है, उसके बाद स्टेट की डेफिनेशन अलग हो सकती हैं, राइट? नाउ वी हैव टू मैच लिस्ट 1 विथ लिस्ट 2. दिस साइड इज केस, दिस साइड इज किस चीज से रिलेटेड है वो, राइट? So case of Indira Swani is related with reservation to backward classes. Minerva Mills case is related to, Gopalan case is related to, and Sankari Prasad case is related to. So Minerva Mills judicial review, right? And Sankari Prasad power of parliament to amend the constitution. फिर कौन हुआ? गोपालन procedure established by law. अगर ऐसे देखोगे which is the option? A का 3, A is 3. Now B 4, C, then C option, C shall be the option. Again, another match the following with writs and what is the purpose of that. So writ of mandamus, these questions जो अभी लास्ट 2-3 क्वेश्चन हमने उठाए हैं, these are taken from the objective Indian polity लक्ष्मीकांत वाले. I'm trying to include current वो objective Indian polity लक्ष्मीकांत वाला because questions उससे आ रहे हैं डायरेक्ट भी. I hope UPSC ना सुन रहा हूँ मुझे. So writ of mandamus, writ of injunction, writ of certiorari, writ of quo warranto. The second writ you might not have heard of, injunction. So injunction actually is a stay order. जो हम लोग बोलते हैं ना कोर्ट से स्टे लेके आ गया. So that in the term of the law is called injunction. Injunction are two types. One is perpetual injunction and second is temporary injunction. So injunction is a stay order on any action or inaction of someone. Right? बिल्डर ने प्रोजेक्ट बना रहा, उस पर आपको स्टे लाना है तो आप इंजंक्शन मांगते हो कोर्ट से. इस कोर्ट से हम स्टे ऑर्डर की प्रार्थना नहीं करते हैं. दैट इज वी डिमांड इंजंक्शन. दैट इज ऑल्सो अ काइंड ऑफ रिट. इन आर्टिकल 32 5 तरीके के रिट्स लिखे हुए हैं, बट ऐसा कोई रिस्ट्रिक्शन नहीं है कि कोर्ट सिर्फ वही 5 दे सकता है ऑर्डर. इफ यू रीड द लैंग्वेज इट इज रिट ऑफ एनी काइंड विच में इंक्लूड दोज 5 काइंड्स ऑफ रिट्स. रिट्स बहुत तरह के होते हैं, है ना. No, High Court can do, and that too in the violation of the legal rights. Writ of injunction is elaborate found in the CPC, Civil Procedure Code. Right. So writ of mandamus is used direction to the officials for the performance of their legal duty. Second, writ is for the ये थोड़ा उधर कर दिया है. Writ of injunction आ गया. Prohibition of an action. Writ of certiorari, transferring of case, and writ of quo warranto, trial of right to a title of a public office, who is holding a public office or not. ये थोड़ा formatting error है, please bear for this. Then this answer shall be A का A होगा, आप लोगों ने मैच कर लिया है. A का mandamus का 2, A का 2, B का 1, C का 4, D का 3. So answer is A. Supreme Court has increased the ambit of right to life to include which of the following? Right to life includes right to live with dignity. Right to life includes right to livelihood. Right to life includes right to receive minimum wages. Right to life includes right to guaranteed employment for 100 days in a year. राइट टू लाइफ इंक्लूड राइट टू लाइफ विद डिग्निटी. ठीक है. राइट टू लाइफ इंक्लूड्स राइट टू लाइवलीहुड. राइट टू लाइफ इंक्लूड्स राइट टू रिसीव मिनिमम वेजेस. और जब ये सब होगा तो कोर्ट क्यों नहीं होगा? हाँ, इट्स ए लीगल राइट. इट्स ए लीगल राइट दो, बट राइट टू लाइवलीहुड आपके पास कहाँ है? राइट टू लाइफ इज ऑल्सो नॉट इंक्लूडेड इन पर से, इट इज ऑल्सो DPSP, बट राइट टू लाइफ में वो भी इंक्लूडेड है ना. So right to life has been expanded. Right to life has been expanded. So if right to life includes right to livelihood, it includes right to life includes right to receive minimum wages. Right to life includes right to guaranteed employment for 100 days in a year. अगर ये दोनों है, मैं क्या बोल रहा हूँ कि right to life includes right to livelihood. This is true. What is right to receive? ये जो आपका 100 days है, वो क्या है? मनरेगा क्या है? अगर आप राइट टू लाइफ की बात करोगे, यार एक तो इसका, अगर आप राइट टू लाइफ की बात करोगे तो राइट टू लाइफ में राइट टू लाइवलीहुड हो सकता है. वो लाइवलीहुड 100 डेज का भी हो सकता है, 200 डेज का भी हो सकता है, 300 डेज का भी हो सकता है, बट राइट टू लाइवलीहुड इज वन थिंग, राइट. Fourth option is saying that right to receive a wage of 100 days is right to life. अगर वो 90 days होता तो भी वो सही होता, right. So right to life में per se receiving 100 days wage cannot be included. You can include right to live with the dignity. You can also include right to life. You can also include right to minimum wages, because all of these three things are necessary for a dignified life. A person not receiving the minimum wages, how can we think that they are receiving a dignified life? फिर वो फोर्स लेबर करने पे मजबूर हो जाएंगे, फिर वो बॉन्डेड लेबर करने पे मजबूर हो जाएंगे. So implementation of this 100 days of work is a kind of manifestation of those rights, but it is not per se a right. ठीक है? So our answer here is 1, 2 and 3. अरे तो मैं भी वही No, I was not saying that 4 was is protect. I was just questioning कि क्यों. The term double jeopardy implied under Article 20 of the Constitution. It includes a person convicted by a court of law cannot be punished under the departmental proceedings for the same. B. It punished departmentally cannot be prosecuted in a court of law for the same offence, shall not be prosecuted and punished for the same offence more than once, cannot be subjected to proceedings in a civil court for the disobedience of injunction along with the criminal proceedings. Not more than once. So double jeopardy means that a person has committed one crime. अच्छा ऐसा एक example, if a person has stolen from Mr. A 100 rupees, he has been sentenced for 2 years. After 2 years, he stole 100 rupees again from Mr. A again. Shall he be punished? अरे तो दूसरा ऑफेंस हो गया ना. अब ऐसे करूंगा तो मैं एक बहुत अमीर आदमी को ढूंढूंगा, उसके यहाँ से हर बार मैं 1-1 लाख रुपए चुराता रहूंगा, सजा तो एक ही बार मिलेगी. So meaning the same offense occurred at the same time, occurred at the same kind of offense. इसके लिए person cannot be convicted more than once, but इसके कुछ restrictions हैं. This protects only from the conviction, not from the trial, and secondly, not from the departmental proceedings. अभी ऐसा हो कि किसी एक एसपी ने गोली चला के किसी को मार दिया, डिपार्टमेंट ने उसको सजा दे दी, तुमको सस्पेंड कर दिया अपने पोस्ट से. अब उसने एक मर्डर किया है, शुड नॉट ही बी ट्राइड फॉर दैट. वो तो बोलेगा मुझे डिपार्टमेंटल इंक्वायरी में बता दिया आपने, एक बार तो सजा दे ही दी, क्यों दे रहे हो? तो प्रोटेक्शन फ्रॉम कन्विक्शन बाय द कोर्ट्स, नॉट फ्रॉम एनी डिपार्टमेंटल इंक्वायरी. इफ अ पर्सन हैज कमिटेड वन क्राइम and he has been punished for by the departmental inquiry once, still he can be punished by the court. That protection is not given, right? वो ऐसा नहीं कर सकता कि मुझे कोर्ट से पनिशमेंट मिल गई तो डिपार्टमेंटल इंक्वायरी क्यों कर रहे हो? These are the two different things. Article 20 subclause 2 will not protect from departmental inquiries, right? It will not also protect from the trial. It only protects from the conviction. So this is answer C. Answer is C. It is possible. सरकारी नौकरी में कहाँ सिर डाल रहे हो? रोज पनिशमेंट मिलेगी. तो डिपार्टमेंटल इंक्वायरी के ऊपर डबल जीओपार्डी नहीं लगती. इट इज बाय द कोर्ट्स. आफ्टर ए कोर्ट हैज गिवन अ सेंटेंस. नाउ ऐसा नहीं कि आज 5 साल की सजा हुई, कल वो केस रीओपन नहीं हो सकता. देयर मे बी 4 और 5 अक्यूज्ड हु आर लेट फ्री, राइट? तो वो सिचुएशन में केस रीओपन हो सकता है. तो आप नहीं कर सकते मुझे एक बार सजा दे दिया. For the same offense, you cannot be convicted more than once. Others can be convicted. You can be tried second time also. That is possible. डिपार्टमेंटल इंक्वायरी आप पे याद की है, बोला कि नहीं उस समय के हिसाब से अच्छी फाइन नहीं लगाई थी, दोबारा करते हैं, तो कुछ चीज मिस हो गया था. देयर इज डिस्कवरी ऑफ न्यू फैक्ट, फिर भी हो जाएगा. ठीक है. हाँ, it is not protecting from the trial. I'll have to change this option. It will not protect from trial. This is very sure. It will protect only from the conviction. Article 20 subclause 2 will protect from conviction. पर्सन के ऊपर दोबारा से ट्रायल शुरू की जा सकती है, हाँ, फॉर द सेम ऑफेंस. देयर आर मे बी मल्टीपल पर्सन एसोसिएटेड. देयर मे बी वन फैक्ट इशू. आपने क्या किया, किसी को किडनैपिंग कर ली, फिर उसका मर्डर कर लिया. आपके पास से सिर्फ डेड बॉडी मिली थी, पुलिस ने ऊपर आपके ऊपर सिर्फ मर्डर का चार्ज लगाया, आपको 4 साल की सजा मिली, 10 साल से 12 साल की सजा मिली. नाउ हैड दिस न्यू फैक्ट बीन कम टू द नॉलेज ऑफ द कोर्ट, किसने किडनैपिंग किया, रेप किया, फिर मर्डर किया, तो मामला आपके ऊपर अलग हो सकता था, है ना? तो रीट्रायल पॉसिबल्स हैं. बट एक ही काम के लिए 2 बार सजा नहीं मिल सकती। आपको मर्डर का सजा मिल गया है, वो दोबारा नहीं मिलेगा। ये रेप और किडनैपिंग वाली सजा तो आपको नहीं मिली है ना, प्रीवियस। Which of the following fundamental rights is available to the citizens and aliens? Right to equality of opportunity, ये आगे का इन पब्लिक एम्प्लॉयमेंट छूट गया मेरे से। इन राइट टू फ्रीडम अंडर आर्टिकल 19, पब्लिक एम्प्लॉयमेंट छूटा नहीं, नीचे आ गया है, ये फॉर्मेटिंग वालों ने आज बसट किया भाई, मेरी कुछ गलती नहीं है, ठीक है। कल्चरल एंड एजुकेशनल राइट्स, राइट टू इक्वलिटी बिफोर लॉ, डी। So Article 16 protects right to equality in right to equality of opportunity in the public employment, right to freedoms under Article 19. So this is 16, this is Article 19. Cultural and educational right 29 and 30, and this is Article 14. So 14 is guaranteed to the citizens, also non-citizens. Right? Okay. Right to freedom of religion guaranteed under Article 25 of the Constitution is subject to which of the following? Right to religion under Article 25, public order, morality, and to the other provisions of Part 3 of the Constitution, public order, morality, and health, reasonable restriction in the interest of the security of the state, public order, morality, health, and to the other provisions in the Part 3 of the Constitution. D. Okay? Public order, health, and morality, and your right to freedom of religion is also subject to other fundamental rights also, right? So this is इसमें आपके कितने क्वेश्चन है? Around 127. We are pausing it here. That we will be taking up tomorrow, and tomorrow 50 more questions. ठीक है? कल थोड़ा फास्ट ले जाएंगे. Thank you. Any conclusion? Any doubts? 107 का आंसर. क्या है? बी, बॉम्बे. So IUC from YouTube, answer to 107 is B for Bombay. अरे ऐसा क्यों गलती करते? वेट सी आएगा ना? इट इज अवेलेबल अगेंस्ट बोथ. सी, हाँ. C 10 is C.
ऑडिट वाले थे, तो जो सीक्रेट सर्विस का होता है वो ऑडिट कर ही नहीं सकता.
नहीं.
तो सीक्रेट सर्विस के पैसे कहाँ से आता है? उसमें कंट्रीब्यूशन फंड था और वो कंट्रीब्यूशन फंड था, तो पीजी फंड तक में
सीक्रेट सर्विसेज का पैसा जो आता है दैट इज अनडिस्क्लोज्ड एज ए हेड ऑफ एक्सपेंडिचर, बट वो पैसा तो कंसोलिडेटेड से ही आता है. वोट ऑफ क्रेडिट से आता है सीक्रेट सर्विस.
ऑल कंसोलिडेटेड.
हाँ, तो कंसोलिडेटेड फंड का ऑडिट